everyone. I'm Leslie Rohde with AskTheLawyers.com, and welcome to another episode of Ask the Lawyers. We get questions from married couples here considering divorce, and some of the common questions include, am I entitled to alimony, or will I have to pay alimony to my spouse? We've invited an expert to help us sort through these questions. Kelli Hooper practices divorce and family law in the greater Atlanta area. She has offices in Atlanta and in Fayetteville, Georgia. She's the incoming chair of the family law section of the American Association for Justice. She is the chair of the Child Support Committee for the American Bar Association. Kelli, thank you for being with us today.
No problem. Thanks for having me.
Let's talk about alimony there in Georgia. What types of alimony are there?
Well, I think it's really great that you started by asking about the particular state, because as it turns out, across the nation, the alimony rules are different depending on what state you're in. So in particular, here in Georgia, there are two different types of alimony. We have temporary alimony and permanent alimony. The names are actually a little deceiving because temporary alimony is designed to be awarded to parties during a divorce proceeding, and permanent alimony is anything that happens subsequent to a final order. So, the names can be confusing because you might think that temporary alimony is just something that's for a short period of time, or that permanent alimony is something that lasts a long time or maybe permanent, but that's actually not the case here in Georgia.
The definitions may be a little different than you think. Thanks for clearing that up. So what does a court look at? What factors does a court consider when they're trying to decide whether to go with temporary or permanent alimony?
Well, it really comes down to the behavior of the parties. In some states, there are schedules and caps even on the amount of alimony that you can get in a divorce. Here in Georgia, the sky's the limit. We look at the income of the parties. You look at the corpus of the marriage, or the assets and debts of the marriage. You look at the ability of the payor, the potential payor, to pay. And then you look at the person who would be receiving the alimony and see, well, how much would they actually need in order to maintain the status quo? If you were to look way, way back into the beginning of alimony and how courts began awarding it, you would notice that it really was intended to maintain the status quo when a marriage ends. And so we still work towards that ideal when trying to craft an agreement or asking the court for a judgment for alimony.
I've wondered about the length of the marriage. Does a person have to be married for, say, 5-10 years? Or is there a certain limit of the number of years that a person can be married before receiving alimony?
No, actually not. Not here in Georgia, at least. In other states where there's a schedule, as we talked about, so there might be length of time and then the assets of the family, and then, you sort of like triangulate that and come up with a number. Here in Georgia, we don't have that. Several years ago, I helped a lady who was only married for 2 weeks get a very sizable alimony payment. What it comes down to is the actions of the parties. It comes down to the ability to pay, and those factors. But the length of the marriage, while you would expect for it to have more impact, it really doesn't.
I know you've been working there in Georgia for a number of years. Have you seen any changes to alimony in Georgia or across the nation?
Well, I mean, everyone has across the nation. So when the new tax law went into effect, what we saw during 2018 is divorce attorneys across the country seeking to educate our clients about the implications of the new tax law and what changes they could expect after December of 2018. So under the old rules, when someone paid alimony, then that was a deductible event for them as a tax-wise, and then the recipient had to record that income as that alimony payment as income. Under the new tax rules, it's no longer a deductible event for the payor, and the receiver does not have to report the alimony income as actually income. So that was a game changer. And I can tell you, any divorce attorney across the nation can tell you what an impact the new tax law had on their domestic practice.
I can see that. Any other trends that you're seeing there in terms of temporary maintenance and permanent maintenance?
Well, no real changes for temporary maintenance or permanent maintenance. So again, temporary here in Georgia means just an award of funds from, one party to the other during the pendency of a divorce proceeding. So we don't really see much change in that. It's really based on, the income of the parties and the ability to pay. I think the real changes that we're seeing in practice, and there's a lot of gray area right now, is where it comes to how we structure alimony payments and settlement agreements, whether we're encouraging parties to make a lump sum payment or whether we're encouraging them to put funds in an IRA to transfer over to the receiving party. And all of that comes down to the tax implications. If there is a high earning spouse who's making a payment to a low earning spouse, then of course the tax considerations are more significant for the party with more income. And so what you're seeing right now is a lot of creativity in domestic practice when it comes to how we're advising our clients to handle those payments.
I've had friends go through divorce, and she was at home with the kids for years and years. She hadn't been in the workforce for a while. Tell us, when you see that type of a case, does that affect alimony in the end?
Well, I don't know if it affects alimony in the end. I think that it's certainly on the table. And it really is a fact-sensitive inquiry, as is most things in family law. So you would look and see, if that person walked into my office, I would have several questions for them. The first would be, was there agreement in your marriage that you were to stay home and forego having an income deriving profession in order to take care of children? Because I'm the first one to tell you that, a lot of times stay-at-home moms probably work harder than those of us that have 9-to-5 jobs. And so sometimes in relationships, there may be a moneyed spouse or the spouse with the higher income who can make more money, and there's an agreement that the other spouse should stay home. If in that instance there has been an arrangement, then certainly there should be some alimony, because likely part of that agreement is the one who stayed home was foregoing their ability to earn in order to take care of children. And so to maintain the status quo, then you would expect that the moneyed spouse or the working spouse would make payments to the other spouse in the event of a separation or divorce.
Whether she goes back to work or not.
Well, whether she goes back to work or not. You see a lot of that in couples where, one has really helped the other one through an MBA program or through a doctoral program or through law school or medical school. And the idea is, hey, I'll stay home and take care of the kids while you go and, sort of live your best life. But if the agreement was, well, while I'm doing that, my expectation is that you're going to take care of home, and then the marriage breaks up, well, then obviously there's an expectation of the spouse who's staying home and taking care of children, that there would be some support while they got back on their feet to make it so that they can earn on their own. The idea generally for alimony is that, you're maintaining the status quo, as I've indicated, but also to help the one who hasn't been working get to the point where they can support themselves. So generally, what I will often do in a lot of my orders is dictate for a period of time. If one of the spouses is in school, then the alimony will last, during the period of time while this person is in school, and maybe a little time afterwards to help them get through their program, become, self-sufficient and able to earn on their own. And then the expectation is alimony would go away, they'd be able to earn on their own, and everyone can move on.
I see. What about fault, Kelli? Like something like adultery or abuse or any other kind of fault. How does that affect an alimony case?
Well, the court looks at the behavior of the parties. So the first thing I tell people when they come into my office and they're asking about alimony is I make sure that they understand that the court is going to look at the behavior of each party. It's not so much about who's filed for divorce, but it's really what's the reason for the breakup of the marriage. If the spouse who was the reason for the breakup of the marriage is now seeking alimony, that's usually not a case that's not a fact pattern that I would be supportive of. It really works out a lot better when you have the person who is not the reason for the breakup of the marriage asking for alimony. It's actually in the statute. One of the things that the court can consider is who is the reason for the demise of the marriage.
Can alimony be modified in any way or changed after a divorce?
It can. And there are a couple of things that people need to understand if they are in sort of post-divorce litigation or they're seeking to modify an alimony payment post-divorce. The first thing is you need to look at your settlement agreement and see whether or not you've waived your ability to modify. One party or both parties can waive their ability to modify alimony payments in subsequent litigations. You need to check and see if you've done that. And if you have not, then you have the ability to go in and ask the court to modify. But it's not, a full-on sort of re-litigation of your divorce proceedings. It really is a narrowly tailored inquiry as to whether or not the alimony payment should change. Generally, you see that when there's been one party who's making payments and then there's been a change in income, a change in ability to earn, or whatever the funds were that were used to determine the alimony that should be paid, right? Because we talked about the inquiry starting with whatever the corpus of the marriage is. So let's say, for instance, the alimony payments were based on the understanding that the husband was making $200,000 a year and they had a house here in Atlanta and one down on St. Simon's Island. Well, let's say, God forbid, husband loses his job and a tornado comes through, or hurricane better, comes through St. Simon's Island and wipes out the house. So there's no income from that house anymore. Well, provided that the husband, assuming he's the payer, has not waived his ability to modify, then that would be a good case to go in and look at modification of alimony.
Any other advice or thoughts that you have for people considering a divorce that have questions about alimony, or maybe people considering marriage who are thinking down the line that?
Well, you certainly, we're telling people now, I say we, family law attorneys, are cautioning people to look at their prenuptial agreements to see what specifically it says about alimony, because it's very likely if those documents were drafted prior to the tax rule, then they contemplated the taxable events occurring, right? So you may need to go back in. If you have a prenup that's been signed, you may need to go in and change it to a postnup and adjust for the new tax situation that we have. And then I would just encourage people that, you should always speak with an attorney, probably one or two, before you decide on filing for divorce, and really sort of look at the assets of the marriage to determine if that's something that's going to be available to you.
And I would assume it would be best to contact an attorney who does specialize in family law like this.
Oh, absolutely. Absolutely.
Kelli Hooper, thank you so much for all of this information. You've helped us understand this so much better.
Oh, no problem. Thanks for having me.
And thank you all for watching another episode of Ask the Lawyers. We want to remind you all to click on the icon on the bottom right-hand corner of your screen so you can subscribe to our YouTube channel and not miss any episodes of Ask the Lawyers. I'm Leslie Rohde with AskTheLawyers.com, where you can choose a lawyer that lawyers choose.